Hello, my name is John P.L.L.C. with the P.L.L.C. Law Firm, a probate and business litigation firm in downtown West Palm Beach, Florida. And I'm going to be speaking to you now, not about the Florida probate rules, but what executors, personal representatives, and beneficiaries, as well as probate lawyers in Florida, need to know about 733-106, a Florida statute on attorney's fees in the probate code. More specifically, I'm going to be speaking to you about one case you want to read, in addition to the most recent case on the issue of if a beneficiary who attacks a will or files a petition to revoke probate is personally liable for attorney's fees if they fail in their petition, if they are not the prevailing party. On April 8th of 2016, the Second District Court of Appeal released the Anderson decision, Anderson v. McDonough, where the Second District came out and said that somebody who is trying to attack probate, who is filing an objection to probate, an objection to a will, or trying to overturn a will in a Florida probate, is not personally liable for attorney's fees. Now, they may be liable for the amount of their inheritance in the probate. So if somebody files a petition to revoke probate or to overturn a will, and they lose, the estate of the personal representative of the Florida estate will probably file a motion for attorney's fees. And under 733-106, Florida Probate Code 733.106, the losing side can be assessed attorney's fees from their share of the estate. The judge in the probate court has the authority to direct where those attorney's fees shall be paid for or from by the losing party. So the short of the Anderson case is there is no personal liability if you lose your probate litigation lawsuit, but you do have at risk costs because the losing party will pay costs as in chancery proceedings, and in chancery proceedings in Florida, to the victor go the spoils. So the losing party will pay costs to the prevailing party in a failed probate lawsuit. But attorney's fees can be assessed under 733.106 only to the extent of one's interest in the estate. So if you only inherit $100,000 and the attorney's fees are $200,000 and you fail, then you're only out of pocket $100,000. You're not personally liable. The other case that you should read is the Dayton v. Conger case. It's a Florida case, 448 Southern 2nd 609, 448 Southern 2nd 609. It's an April 17, 1984 decision out of the 3rd District in Florida, and it was actually cited by the Anderson v. McDonough case. Now, the one exception to this rule that there's no personal liability for a failed attack on a probate or to overturn a will is in the limited circumstances when somebody engages in bad faith litigation or a frivolous lawsuit. Now, to get somebody to be personally responsible for attorney's fees in a failed probate litigation beyond the extent of their inheritance or beyond the interest of their interest in the estate, you need to do two things. One, you need to file a motion for fees and invoke the inherent discretion of a court to sanction bad conduct and award fees. Two, you want to look at the Bitterman case, a Florida Supreme Court case on bad faith and people acting poorly. And you also want to consider Florida Section 57.105, which requires a 30-day letter in advance of filing the motion for fees. Dayton v. Conger, Anderson v. McDonough, under what circumstances does a beneficiary who fails in Florida probate litigation need to, or under what circumstances is that Florida probate beneficiary personally liable for attorney's fees of the prevailing side? Very limited circumstance. You're not going to find that in the probate rules. You need to read the probate code section 733.106, but more so get your guidance from Anderson v. McDonough. The Westlaw site is 2016 WL 1386145 and the Dayton v. Conger case. That concludes my remarks about 733-106 and the Dayton case and the Anderson case.